I want to be clear on this, just on this last point. This is important because there's lots of Supreme Court precedents that conflict with one another over the years. You will apply the current and controlling precedent to the matter at hand. Is that fair to say?
Yes, without hesitation.
Which in this case you recognize to be the Dobbs case. Is that fair to say?
Yes, I think Dobbs is a recent formulation of the substantive due process test that we're talking about.
That would bind you?
Of course.
Mr. Bove, nice to see you. I enjoyed our conversation the other day. Congratulations on your nomination. If I could, let's turn the focus of the discussion back to the law. I want to talk to you for just a second about your approach to the interpretation of statutes, which is something that we discussed when you and I had a chance to speak earlier. When you encounter, as you will constantly on the Third Circuit, when you encounter an ambiguous statute, what's your general approach? What do you consult? What's your approach to interpreting the text? Give us a sense of how you'll tackle this. What will be a daily occurrence should you be confirmed?
So in the face of an ambiguity, Senator, I would consult the context of the operative phrase, consider the statutory structure, look at usages of similar terms by the operative legislature at the time in question, because I think that matters, as I said earlier, with respect to enforcing bicameralism and presentment, and try to garner as much as can be from those sources, those textual indications. In the event that I think that those textual considerations don't resolve the matter, philosophically, I would be inclined to exercise restraint and not insert myself or a panel of the Third Circuit, if I was confirmed, into a position of declaring what the meaning of an ambiguity is, as opposed to deferring back to the legislature on that topic.
You just used the word text or textualist about 3 or 4 times. Do you consider yourself a textualist? Is that a fair assessment?
Yes, Senator.
Let's just think about a controversy that exists among those who call themselves textualists. Some textualists say that the statute ought to be interpreted, an ambiguous phrase ought to be interpreted according to the public understanding at the time that the statute was enacted. Other textualists, self-identified textualists, say that a text meaning sometimes only becomes clear over time. So there needs to be, in a lapse of time, you can consider what's happened in a space of time rightly to interpret an ambiguous phrase. Both camps call themselves textualists. Where do you fit?
In the first one, Senator, I think that an interpretive methodology that allows the meaning of a statute to shift over time, potentially over the course of interpretations by different judges under different circumstances or at the whims of policy or political considerations, can be very problematic. If I were confirmed, part of my philosophy would be to do this job pursuant to the limited powers in Article 3 in a way that enhances the democratic features of the political branches. And by that, I mean focusing on the text, what it meant at the time it was put on the books, and deferring to those political branches on the other matters. Okay,
good. So I hear you to say that you reject the idea that an act's meaning can only become clear over a number of years. You think it ought to be interpreted as understood at the time it was enacted by the public, meaning at that time. Have I got that right?
Yes.
Good. Let's talk about substantive due process for just a moment. What's your understanding of that doctrine?
I think there's a basic test set forth in Supreme Court precedent that I would apply faithfully if I'm fortunate enough to be confirmed, that seeks to identify certain fundamental rights as a matter of substantive due process. That precedent, the precedent for that test, as I understand it, basically requires consideration of whether the right at issue is implicit in the concept of ordered liberty and also consistent with deep history and traditions of the Republic. There's a lot of academic writing about the merits of that test that I think for judges, particularly me, if I'm confirmed, is sort of beside the point. Because on the Third Circuit, I'd be bound by Supreme Court precedent, like the Glucksberg case, to apply that test in the context of arguments presented to me by the parties.
What is the leading Supreme Court precedent on substantive due process, to your knowledge?
I think There's several cases that lay out and address the test that I just described in the context of discussing different fundamental rights. Dobbs is one of them. I mentioned the Glucksberg case, which is an older formulation of that test.
Yeah, in fact, the Supreme Court has used different tests over time. The substantive due process has two branches. No, it has the incorporation branch, and then it has the fundamental rights branch. You've been describing the fundamental rights branch. The court has used different tests over the years, frankly, to describe what counts as a fundamental right. Those tests are quite divergent, if we're being honest. But this court seems to have settled on one recently, and I think you just put your finger on the decision that most recently draws these themes together, these strands together. That's the Dobbs decision. Do you regard the Dobbs decision as settled law?
Yes.
As controlling law?
That is what I mean, is that it's a binding precedent of the Supreme Court that I would be required to apply faithfully if I'm confirmed.
And so you will apply the Dobbs decision not only in the context of life and abortion, which is the immediate context, but also for its instruction on the meaning of fundamental liberties under the substantive due process head. Is that correct? Is that fair to say?
I think it's fair to say that a judge endeavoring to be bound by the rule of law, which is certainly what I would be trying to do, applies all relevant Supreme Court precedents in a faithful way. And that would be my mission for life if I am confirmed.
But sorry, I want to be clear on this, just on this last point. This is important because there's lots of Supreme Court precedents that conflict with one another over the years. You will apply the current and controlling precedent to the matter at hand. Is that fair to say?
Yes, without hesitation.
Which in this case you recognize to be the Dobbs case. Is that fair to say?
Yes, I think Dobbs is a recent formulation of the substantive due process test that we're talking about.
That would bind you?
Of course.